Why did my probation officer violate me for missing our meeting when I was in emergency surgery? The deputy handed me the arrest warrant through the hospital room door while I was still connected to an IV drip and drainage tubes from my emergency appendectomy. I was 36 hours post-op, barely able to sit up without feeling like my abdomen was tearing apart. And this guy in a brown uniform was reading me my rights for violating probation. My lawyer had told me violations were serious, but I'd assumed that meant if you actually violated your terms. I'd been in surgery, literally unconscious on an operating table, having my burst appendix removed, while my probation officer, Leonard Vance, sat in his office, marking me as a no-show for our mandatory monthly check-in. The warrant stated I'd failed to appear for a required meeting, demonstrated disregard for court-ordered supervision, and posed a flight risk requiring immediate custody. I tried to explain about the surgery, about the emergency, about the fact that I'd been medically incapable of attending any meeting. The deputy's expression was apologetic, but firm. He said the warrant was valid and he had to execute it. He said I could explain everything to the judge at my violation hearing. He gave me 20 minutes to get discharged against medical advice, or he'd transport me in a wheelchair still wearing a hospital gown. My surgeon, Dr. Alan Cho, came in looking furious and concerned. He said I shouldn't be moving at all, that I was at high risk for complications, that leaving the hospital 36 hours after emergency abdominal surgery was medically dangerous and potentially life-threatening. The deputy said he understood, but had no discretion to delay execution of a valid warrant. I signed the discharge papers with hands that wouldn't stop shaking, got dressed in clothes my sister had brought, and walked out of St. Vincent's Medical Center in handcuffs while my surgical incision screamed with every step. I'd been on probation for 14 months when this happened. The original charge was a DUI from 2 years earlier, my first and only criminal offense in 29 years of life. I'd made the catastrophically stupid decision to drive home from a friend's birthday party after having 3 beers over 4 hours. I'd felt fine, thought I was under the limit, and got pulled over for a broken tail light 2 blocks from my apartment. The breathalyzer showed .09, just over the legal limit, and I was arrested. The whole experience had been humiliating and terrifying. I'd spent a night in county jail, hired a lawyer named Thomas Riley who specialized in DUI defense and had 16 years of experience, and eventually accepted a plea deal. The deal included 1 year of probation, mandatory alcohol education classes, community service, and installation of an ignition interlock device on my car. The probation terms were strict but straightforward. Monthly meetings with my probation officer, random drug and alcohol testing, maintenance of employment, no new arrests, and compliance with all court-ordered programs. I'd followed every single requirement perfectly for 14 months. I had attended every meeting, passed every test, completed my community service, finished the alcohol classes, and kept my job as a software developer at a tech startup called Nexus Solutions. I'd rebuilt my life after the DUI, paid my fines, learned from the mistake, and was 8 months away from completing probation and having the whole thing behind me. My probation officer for the first year had been a woman named Rachel Dunn, who'd been professional and reasonable. She checked in monthly, verified my compliance, and generally treated me like a functional adult who'd made one mistake and was working to fix it. Then Rachel retired, and I got reassigned to Leonard Vance. Leonard Vance was maybe 50 years old, had worked in probation for 18 years, and ran his caseload like a military operation. Our first meeting happened in early January, 3 months before the appendicitis incident. His office was in the County Probation Department building, a depressing concrete structure downtown with fluorescent lights and institutional green walls. Leonard was tall, thin, with graying hair and cold eyes that seemed to assume guilt before questions were even asked. He'd reviewed my file while I sat across from his desk and immediately started asking questions that felt accusatory rather than supervisory.
He wanted to know why I'd only listed one job when most people my age had employment histories showing multiple positions. I explained I'd been at Nexus Solutions for 3 years and didn't see a reason to leave a job I liked. He made a note that seemed skeptical. He asked why I lived alone instead of with family or a partner. I said I preferred living alone and could afford my own apartment. Another note. He asked whether I had any firearms in my residence. I said no, which was true and also irrelevant since my probation terms didn't prohibit gun ownership. He wrote something down and said he'd be scheduling a home visit to verify my living situation. The entire meeting felt wrong, like Leonard was looking for violations rather than monitoring compliance. When I mentioned this to my friend Danny afterward, he said some probation officers were just like that, power trippers who enjoyed having authority over people. I'd hoped it was just an awkward first meeting, and Leonard would relax once he saw I was compliant and stable. The home visit happened 2 weeks later, unannounced, on a Thursday evening while I was making dinner. Leonard showed up with another probation officer, a younger man named Carl Simmons, and asked to inspect my apartment. I let them in, confused but cooperative. They walked through every room, opened cabinets and closets, looked through my mail, examined my refrigerator contents. Leonard asked why I had 3 bottles of wine in a rack on my kitchen counter when I was on probation for an alcohol-related offense. I explained that my probation terms didn't prohibit alcohol possession, only consumption, and that the wine belonged to my sister, who'd left it there after visiting. Leonard said it was suspicious that I'd keep alcohol in my home given my history. I pointed out that my probation conditions explicitly allowed me to possess alcohol as long as I didn't consume it, that I'd passed every random alcohol test for over a year, and that the wine bottles were dusty and clearly untouched. Leonard made extensive notes and said he'd be recommending more frequent testing. The visit lasted 45 minutes and felt like harassment. After they left, I called Thomas Riley, my lawyer, and asked if probation officers were allowed to conduct warrantless searches like that. Thomas said yes. Probation terms typically included consent to searches as a condition of supervised release. He said Leonard seemed overzealous, but technically wasn't violating my rights. He advised me to document everything, keep records of all interactions, and contact him immediately if Leonard took any actions that seemed retaliatory or unreasonable. I started keeping a detailed log of every contact with Leonard, every meeting, every phone call, every interaction. The mandatory monthly meetings with Leonard became increasingly tense over the next 2 months. He'd ask the same questions repeatedly, trying to catch inconsistencies. He'd question why I'd gone to specific places that showed up on my bank statements, treating normal activities like grocery shopping or going to the gym as potentially suspicious. He'd schedule our meetings at inconvenient times, like 8 a.m. on Monday mornings when he knew I had standing work meetings, then act annoyed when I asked to reschedule. When I showed up exactly on time, he'd comment that I seemed too punctual, like I was trying too hard to appear compliant. When I was 5 minutes early once, he suggested I had too much free time and maybe needed more community service hours. Nothing I did was right in his assessment. Other people in the probation office waiting room had started noticing. One guy, Antonio, who I'd seen there multiple times, told me Leonard had a reputation for being harsh and for violating people on minor technical issues. Antonio said Leonard had violated him 6 months earlier for missing a drug test when Antonio had been hospitalized with pneumonia. He'd fought the violation, eventually got it dismissed, but spent 3 weeks in jail while the legal process played out. He said Leonard seemed to target people who were doing well on probation, like he needed to prove they weren't as reformed as they appeared. I had found this hard to believe until it started happening to me.
The appendicitis hit without warning on a Sunday evening in early April. I'd been feeling vaguely unwell all day, general stomach discomfort that I'd attributed to something I ate. By 7 p.m., the pain had localized to my lower right abdomen and intensified to the point where I couldn't stand up straight. By 8 p.m., I was sweating and nauseous with pain that felt like someone was stabbing me. My sister, Vanessa, who lived 15 minutes away, came over when I called her, sounding panicked.
She took one look at me and drove me straight to St. Vincent's emergency department. The ER doctor, a woman named Dr. Lillian Foster with 12 years of emergency medicine experience, examined me and immediately ordered a CT scan. The scan showed acute appendicitis with signs of rupture. Dr. Foster said I needed emergency surgery within the next 2 hours or I risked sepsis and potentially fatal infection. The on-call surgeon, Dr. Alan Cho, came down to review the scans and confirm the diagnosis. He explained that my appendix had burst, that contaminated material was leaking into my abdominal cavity, and that they needed to operate immediately to remove the appendix, clean out the infection, and prevent complications. I signed consent forms while Vanessa called our parents. The anesthesiologist, Dr. Raymond Park, with 19 years of experience, started an IV and explained the anesthesia process. I was in the operating room by 10:30 p.m., unconscious and having emergency abdominal surgery while my burst appendix was removed and my abdomen was irrigated to clear the infection. The surgery took 3 hours. I woke up in recovery around 2 a.m. Monday morning, feeling like I'd been hit by a truck, with surgical drains coming out of my abdomen and pain medications flowing through my IV. My mandatory monthly probation meeting with Leonard Vance was scheduled for 10 a.m. Monday morning, 8 hours after I woke up from surgery. I was barely conscious Monday morning, still heavily medicated, with strict orders from Dr. Cho to remain hospitalized for at least 48 hours for monitoring. Vanessa had my phone and my wallet stored in the small cabinet next to my hospital bed. When I was alert enough to think clearly around 9 a.m., I asked her to call Leonard's office and explain what had happened. She called the probation department number and asked for Leonard Vance. The receptionist transferred her. Leonard answered, and Vanessa explained that I was hospitalized, had undergone emergency surgery overnight, and obviously couldn't attend the 10 a.m. meeting. She offered to fax or email documentation from the hospital. According to Vanessa, Leonard's response was cold and skeptical. He said missed appointments required advance notice, not day-of excuses. Vanessa said this was an emergency, that I'd literally been unconscious in an operating room during hours when I could have called. Leonard said that didn't change the requirement for advance notification, that I should have called before the meeting time. Vanessa asked how someone could call before a meeting when they were having emergency surgery. Leonard said that wasn't his problem, that the probation terms required attendance at all scheduled meetings unless excused in advance, and that failure to appear constituted a violation. Vanessa asked to speak to his supervisor. Leonard said he was the supervisor on my case, and the decision was final. He hung up. Vanessa stood next to my hospital bed looking shocked and told me what had happened. I thought she must have misunderstood, or that Leonard was just being bureaucratic and would ultimately excuse the absence once he saw the medical documentation. I was wrong. The violation report was filed by Leonard at 11:30 a.m. Monday morning, 90 minutes after the missed meeting time and while I was still in a hospital bed recovering from emergency surgery. The report stated that I'd failed to appear for a mandatory probation meeting without prior authorization, that I demonstrated a pattern of challenging supervision requirements, and that my non-compliance posed a risk to public safety, requiring immediate custody. The report included Leonard's recommendation that my probation be revoked and I serve the remainder of my suspended sentence in county jail.
None of it mentioned the emergency surgery. None of it acknowledged that Vanessa had called to explain. It read like I'd simply blown off the meeting with no excuse. Based on this report, a judge signed an arrest warrant Monday afternoon. The warrant was transmitted to the sheriff's department for execution. On Wednesday morning, 36 hours after my surgery, Deputy James Garrett arrived at my hospital room to arrest me. Dr. Cho tried to intervene, tried to explain that I was medically unstable and needed to remain hospitalized. Deputy Garrett said he sympathized, but had a valid warrant he was required to execute.
He gave me the option of being transported in handcuffs wearing hospital clothes or getting discharged against medical advice so I could dress in regular clothes. I chose discharge because being transported in a hospital gown felt like an additional layer of humiliation I couldn't handle. Dr. Cho signed the discharge papers under protest, marking it as against medical advice and documenting that I was at high risk for surgical complications, infection, and potentially life-threatening consequences from premature discharge. He prescribed antibiotics, pain medications, and wound care supplies. He gave me detailed instructions for monitoring signs of infection. Then I walked out of the hospital in handcuffs while my surgical incisions pulled with every step and got transported to county jail. The intake process at county jail was a nightmare. I had to remove my shirt so they could inventory my belongings and search me. The intake officer, a woman named Officer Diana Cole, saw the surgical dressings and drainage tubes still attached to my abdomen and called for a medical evaluation. The jail nurse, Robert Chen, examined me and said I shouldn't be in jail, that I needed hospital-level care, that the risk of infection and complications was serious. He documented his medical concerns and said he'd report them to the jail medical supervisor, but there was no mechanism to refuse intake based on medical issues unless I was actively dying. I was processed, given jail clothes that irritated my incisions, and placed in a medical observation cell by myself. The cell had a metal bunk, a toilet, and nothing else. I spent that first night lying on a thin mattress trying not to move because every movement hurt. The antibiotics and pain medications Dr. Cho had prescribed were confiscated during intake because outside medications weren't allowed. The jail medical staff had to review and reapprove everything, which took 18 hours. I spent those hours in escalating pain and fear that my incisions were becoming infected. Thursday morning, the jail doctor, Dr. Susan Kapoor, with 8 years of correctional medicine experience, examined me and said the discharge against medical advice had been medically irresponsible, that whoever had approved my arrest should have delayed it until I was medically cleared, and that I was now her problem. She restarted the antibiotics, provided different pain medications, and ordered daily wound checks, but she couldn't release me from jail. Only a judge could do that. My violation hearing was scheduled for the following Monday, 5 days after my arrest, 8 days after my surgery. Thomas Riley, my lawyer, visited me in jail Thursday afternoon, looking furious. He said he'd been trying to reach me since Wednesday, when Vanessa had called him about the arrest. He'd filed an emergency motion to dismiss the violation and release me on medical grounds. The motion included declarations from Dr. Cho and Dr. Foster about the emergency surgery, copies of my surgical records and discharge paperwork, and arguments that arresting someone for missing a probation meeting while unconscious in surgery was absurd and violated due process. The judge assigned to the motion, Honorable Patricia Kemp, with 11 years on the bench, had denied it. Her order said that while the circumstances were unfortunate, the violation report alleged non-compliance with probation terms and required a full hearing to assess the facts. She said I could remain in custody pending the hearing or post a $5,000 bond.
Thomas said posting bond while recovering from surgery and potentially unable to work was financially dangerous, but staying in jail with fresh surgical wounds was medically dangerous. We agreed to try to get the hearing moved up, and in the meantime, I'd stay in jail under medical observation. Thomas said he'd be subpoenaing Leonard Vance's complete records on my case, the call logs showing Vanessa's notification and witness testimony from my sister and the medical staff. He said this should be a straightforward hearing, resulting in dismissal, but Leonard's violation report was so aggressively adversarial, it suggested something else was going on. The something else became clear when Thomas received Leonard's file on my case through discovery. The file contained notes Leonard had been keeping since he'd taken over my supervision in January.
The notes painted a picture of me as hostile, uncooperative, and potentially deceptive. He documented that I'd questioned his authority during our first meeting, that I'd been defensive about the wine bottles during the home visit, that I'd requested meeting time changes repeatedly to avoid supervision. None of these characterizations were accurate. I'd been polite and compliant at every interaction. The notes about requesting meeting changes referred to a single instance when I'd asked to move a meeting by 30 minutes due to a work conflict, which Leonard had approved. He'd also noted that I'd appeared overly prepared for meetings, bringing documentation and records without being asked, which he interpreted as suspicious rather than responsible. The file included his recommendation, written 2 weeks before my surgery, that I be subjected to enhanced supervision, including weekly rather than monthly meetings, random home visits, and additional drug testing, because my presentation of compliance seemed performative rather than genuine. Thomas said this was textbook bias, that Leonard had decided I was a problem case and was building a narrative to justify violations. The violation report about missing the meeting was just the incident Leonard had been waiting for. Thomas said we'd be arguing at the hearing that the violation was pretextual, that Leonard had been targeting me for months, and that the emergency surgery excuse was undeniably legitimate. The hearing happened Monday morning in a courthouse holding cell because I was still in jail custody. Judge Kemp presided, with Leonard Vance present as the reporting probation officer and Thomas representing me. The state was represented by a prosecutor named Amy Thornton, who specialized in probation violation cases and had 14 years of experience. The hearing started with Leonard presenting his violation report and explaining that I'd failed to appear for a mandatory meeting, that the terms of my probation required attendance at all scheduled supervision appointments, and that I'd provided no advance notice of inability to attend. Thomas cross-examined him, asking whether Leonard had received a call from my sister on the morning of the meeting, explaining I was hospitalized. Leonard admitted he'd received a call, but said it didn't constitute proper notice because it came after the meeting time. Thomas asked if Leonard understood I'd been in emergency surgery. Leonard said yes, but that medical emergencies didn't automatically excuse probation violations, that proper procedure would have been to provide documentation and request formal approval. Thomas asked how someone could provide documentation while unconscious. Leonard said that wasn't his responsibility to solve. The exchange was damning for Leonard, but Judge Kemp's expression remained neutral. Dr. Cho testified next, explaining the medical details of my appendicitis, the emergency nature of the surgery, the impossibility of me attending any meeting while sedated in an operating room, and the medical danger of discharging me from the hospital after only 36 hours. He submitted my complete medical records, surgical notes, and post-op care instructions. He said discharging me to be arrested had put my life at risk, and that whoever had issued the warrant without considering the medical circumstances had exercised appallingly poor judgment. Judge Kemp asked whether there had been any advance warning I might need surgery. Dr. Cho said no, that appendicitis is by definition an acute emergency, that I'd been healthy Sunday morning and in surgery Sunday night. Vanessa testified about calling Leonard's office Monday morning, about his dismissive response, about his refusal to accept a medical emergency as a valid excuse. She submitted phone records showing the exact time of her call, which was 9:04 a.m., 56 minutes before the scheduled meeting. The records proved she'd notified Leonard before the meeting time, contradicting his claim that notification came after the fact. Amy Thornton, the prosecutor, cross-examined Vanessa, asking whether I'd tried to call Leonard directly rather than having my sister call. Vanessa explained I'd been unconscious with anesthesia still in my system and physically incapable of making calls. Thornton suggested I could have called from the ambulance or from the ER before surgery. Vanessa pointed out that when you're in septic shock from a ruptured appendix, calling your probation officer isn't exactly the priority. Judge Kemp asked whether the probation department had any protocol for medical emergencies. Amy Thornton said she'd check and get back to the court. The hearing was continued for 1 week to allow both sides to submit additional documentation and for the court to review probation department policies on emergency situations. I spent that week in jail, now 9 days post-surgery, with wounds that were healing but still painful and requiring daily care. I'd missed almost 2 weeks of work and needed to contact my employer to explain the situation. My boss at Nexus Solutions, a woman named Patricia Hang, who'd been CEO for 6 years, was horrified when I explained what had happened. She said my job was secure, that I should take whatever time I needed to heal and deal with the legal situation, and that if I needed any documentation or support, she'd provide it. She asked if the company could help with legal fees. I thanked her, but said Thomas was working on contingency at this point because he believed there might be grounds for a civil lawsuit against Leonard and the probation department once the criminal case was resolved. Thomas filed a formal complaint with the probation department's Internal Affairs Division during the week between hearing sessions. The complaint alleged that Leonard Vance had filed a fraudulent violation report, had ignored legitimate medical emergency notification, had demonstrated bias throughout his supervision of my case, and had potentially violated department policies regarding emergency exceptions. The complaint included copies of all documentation, Leonard's file notes showing bias, testimony transcripts from the hearing, and declarations from Dr. Cho and Vanessa. Internal Affairs assigned an investigator named Margaret Flynn, who had 21 years of experience in administrative investigations, to review the complaint. She contacted Thomas and said she'd be interviewing Leonard, reviewing his complete case files from the past 3 years and looking for patterns of similar conduct. She said internal investigations took time, but if the allegations were substantiated, Leonard could face discipline up to and including termination. Thomas also filed a motion for immediate release pending resolution of the violation hearing, arguing that continued incarceration of someone who'd been hospitalized for emergency surgery and posed zero flight risk was punitive and medically dangerous. Judge Kemp granted the motion, releasing me on my own recognizance with orders to check in weekly with the probation department's central office, not with Leonard Vance specifically. I got out of jail Wednesday evening, 12 days after my surgery, thinner, weaker, and angrier than I'd ever been in my life. Vanessa picked me up and drove me home. My apartment felt strange and empty after nearly 2 weeks away. The surgical wounds were healing, but still required daily care. I'd missed almost 2 weeks of work and needed to contact my employer to explain the situation. My boss at Nexus Solutions, a woman named Patricia Hang, who'd been CEO for 6 years, was horrified when I explained what had happened. She said my job was secure, that I should take whatever time I needed to heal and deal with the legal situation, and that if I needed any documentation or support, she'd provide it. She asked if the company could help with legal fees. I thanked her, but said Thomas was working on contingency at this point because he believed there might be grounds for a civil lawsuit against Leonard and the probation department once the criminal case was resolved. I spent the next few days resting, attending follow-up appointments with Dr. Cho, who confirmed I was healing properly, and preparing for the resumed violation hearing. The second hearing session happened the following Monday, 3 weeks after my surgery. Amy Thornton, the prosecutor, opened by stating that the probation department had reviewed its emergency notification policies and confirmed that probationers were expected to provide advance notice of inability to attend scheduled meetings whenever possible, but that documented medical emergencies qualified for retroactive excuse if proper documentation was provided within 48 hours. She admitted that my sister's call Monday morning, coupled with the hospital records I'd subsequently provided, met the documentation requirement. She said that in light of this policy and the undisputed medical evidence, the state was withdrawing its support for the violation report and recommending dismissal.
It was an admission that Leonard's violation had been wrongly filed, that I should never have been arrested, that the entire nightmare had been based on either Leonard's ignorance of department policy or his deliberate disregard of it. Judge Kemp accepted the state's recommendation and dismissed the violation. She then did something unexpected. She said she'd reviewed the entire case file, including Leonard's supervision notes and the circumstances of the violation report, and she had serious concerns about the quality of supervision I'd received. She ordered that I be immediately reassigned to a different probation officer and that Leonard Vance have no further contact with my case. She said she was referring the matter to Probation Department Administration for review of Leonard's conduct and potential disciplinary action. She apologized to me directly, saying the court system had failed me and that being arrested while recovering from emergency surgery was an injustice that should never have happened. The apology felt surreal but necessary. The internal affairs investigation into Leonard Vance took 6 weeks and revealed a pattern of misconduct that went far beyond my case. Margaret Flynn's investigation found that Leonard had filed violation reports against 23 probationers over the previous 18 months, a rate nearly 3 times higher than other probation officers with similar caseloads. Of those 23 violations, 11 had been dismissed by judges as unfounded or overly punitive. The investigation found multiple cases where Leonard had ignored legitimate excuses, mischaracterized probationers' conduct in his reports, and recommended incarceration for minor technical violations that other officers would have handled with warnings. Flynn interviewed 15 of Leonard's current and former probationers. Multiple people described experiences similar to mine, feeling targeted, having normal activities characterized as suspicious, being subjected to excessive scrutiny, and living in constant fear of violations for trivial reasons. One woman, Maria Santos, testified that Leonard had violated her for missing a drug test when she'd been at her daughter's emergency room visit for an asthma attack. Another man, DeAndre Williams, said Leonard had recommended violation for changing jobs without prior approval, even though DeAndre had notified Leonard within the required 48-hour period. The pattern was clear and systematic. Leonard had been abusing his authority, filing excessive and unjustified violations, and treating probation supervision as a power trip rather than a rehabilitative process. The probation department suspended Leonard Vance pending the outcome of the internal investigation. He was eventually terminated after the investigation report was finalized. The termination letter, which became public record through a sunshine law request filed by a local legal advocacy organization, stated that Leonard had repeatedly violated department policies, had demonstrated bias in his supervision of probationers, had filed violation reports without proper factual basis, and had damaged the department's credibility and mission. The letter noted that his conduct had resulted in wrongful incarcerations, dismissed violations that wasted court resources, and created liability exposure for the county. Leonard was terminated for cause, losing his pension benefits and his certification as a probation officer. He appealed the termination through his union, but the appeal was denied after an arbitrator reviewed the evidence and agreed the termination was justified. His career in probation was over, ended by the same aggressive violation tactics he'd used against vulnerable people for years. Thomas Riley filed a civil rights lawsuit on my behalf against Leonard Vance personally and the county probation department for false arrest, malicious prosecution, violation of due process, and intentional infliction of emotional distress. The lawsuit detailed my emergency surgery, Leonard's knowledge of the medical situation, his filing of a fraudulent violation report, my wrongful arrest and incarceration while medically vulnerable, and the pattern of misconduct revealed by the internal investigation. The lawsuit sought compensatory damages for medical expenses related to premature hospital discharge, lost wages from missed work, pain and suffering from being jailed while recovering from surgery, and punitive damages to deter similar conduct. The county's insurance carrier reviewed the case and quickly moved towards settlement. The facts were undisputed and damning. Their insured employee had arrested someone for missing a meeting while that person was unconscious in emergency surgery. There was no legal defense that made that acceptable. The case settled 4 months after filing for $185,000. The settlement included a provision requiring the county to implement new training protocols for probation officers on medical emergency procedures, to establish a formal review process for all violation reports before warrants were issued, and to create an oversight board with community representatives to monitor probation department practices. The money mattered less than the systemic changes. The settlement meant Leonard's misconduct would result in actual reforms that might protect future probationers from similar abuse. If you enjoyed this, you'll definitely want to see the next ones too.